Good morning, everyone. We're going to get started. A few moments late. Thank you again. This is day 2 of the Florida Bar's Criminal Justice Summit. Thank you for being here today. For those of you who are just joining us here today and missed yesterday, it was a wonderful day bringing stakeholders together from all around the state to talk about some very important issues that affect all of us, that we care about, which is why we're here. So without further ado, I'm going to introduce Hank Cox, the chair of the summit, who is going to introduce our keynote speaker this morning.
I spent a lot of years fighting that anything begin at 8 o'clock in the morning, so whoever I'm apologizing for, I apologize. I have a lot of extra drink tickets if anybody needs any. I don't know what you do with them. They're dated October 16th, so I'll leave them up here on the podium for anyone who would like one. Before I introduce Nina, just as a reminder, in the Hillsborough room is a direct file and juvenile sentencing back-to-back workshops, and the specialty court and mental health workshops are in the Duval room downstairs. And then we return here where lunch will be provided. Having said all that, let me introduce a longtime friend and friend to others in this room, Nina Morrison. Nina is a senior staff attorney at the Innocence Project in New York with Barry Scheck, has worked throughout the nation on what the Innocence Project does, which is to make criminal justice systems better. Graduate from Yale University, graduate of NYU Law School, clerk for the United States Court of Appeals for the Second Circuit in New York. She has worked in Florida many times. She has been counsel or co-counsel, I believe, on 27 different exonerated individuals in the state of Florida from death row or other other prison sentences. So with nothing further to take up her valuable time, let me introduce Nina Morrison, and welcome to Florida again. Nina.
Thank you, Hank, and thank you all for having me. Just one quick correction. I haven't exonerated 27 people in Florida. That's the national number of cases I've worked on, although I will say that when I was a baby lawyer, Florida is the place where I stumbled through my first post-conviction hearing, and I survived, so I'm really glad to be here today. I have had 3 exonerations in Florida and seen a lot of changes in this state and elsewhere, it's really my pleasure to be here and talk to you about a subject that obviously is very near and dear to me because I've been doing this work for close to 17 years now. When I got out of law school, a lot of people who knew me well told me not to go into criminal law. They said it's too depressing, or too much of an optimist, nothing good happens in a criminal courthouse, even when cases resolve the way they're supposed to. There's just a lot of pain, an acquittal, a conviction. But I have been very lucky that I have had the pleasure to have moments of real joy in a criminal courthouse. This man, John Notley, was my client who I represented for 12 years. He was exonerated 2 weeks ago on October 3rd, 2018, after 21 years behind bars for a crime he didn't commit. These are moments that come with a lot of pain. He lost time with his children who are now adults. This is his new baby who he had with actually a friend from middle school he fell in love and got married to a year after he got out of prison on bond 2.5 years ago while we were working on the final stages of his case. So I don't want to understate how much pain and suffering goes behind these moments of joy. But what happened to Mr. Notley that was so wonderful was not just that he got his name cleared. It was that we were able to clear him as the result of a joint reinvestigation that we did with the full cooperation and the extraordinary efforts of the district attorney's office in Fort Worth, Texas. They elected a new DA a few years ago. She hired someone to run a new unit I'll talk about a little later called a conviction integrity unit, and that lawyer worked with me for the better part of 3 years to go back and dig up new evidence that proved Mr. Notley's innocence. And on the day he was exonerated, it wasn't just a formality. There was a full courtroom. The judge apologized to him for what he had been through. And the district attorney got up and talked about her obligation as the chief lawyer for the county representing the state to make things right. That doesn't happen every day in our criminal courts. And what keeps me coming back to the work and what I want to talk about today that Hank and Sandy suggested this topic, and I was happy to tell them I had plenty of material, is what happens after those moments, how we have worked with lawmakers, with prosecutors, with judges to try to make the system better and prevent what happened to people like Mr. Notley from happening to anyone else. We've made a lot of progress. There's still more to do, but I am pleased to talk about some of what we've had. I'm actually going to look west a little bit today and talk to you about two cases that I handled in Texas, Mr. Notley's and another case, and the aftermath of those exonerations and how we were able to make lemonade out of the proverbial lemons and get some real reforms in place. We have done this a little bit because of the human stories, so I'm going to tell one story in some detail. You know, people have known that there are wrongful convictions. Everyone who works in criminal justice has known this for decades. But it was really the confluence of DNA evidence that could prove it scientifically, starting about 25 years ago, and frankly, the internet, which could broadcast images like these all around the world to bring them into people's homes. So if you didn't see the evening news, the stories would continue for days or months or years. So because of these technological advances and then kind of some magic factors that all came together, we've really made a lot of progress. So the first case I want to talk about is a client of mine, Michael Morton, pictured in the mustache, obviously, on the left, and then in the center on the right, on the day of his exoneration back in 2011. Michael's case involved one of the worst tragedies you could imagine. Every wrongful conviction is a tragedy, but he was wrongly convicted of killing his own wife, Christine. And he went to prison for 25 years and lost custody of his only son during that time. His son was raised thinking wrongly that Michael had not only committed a horrible crime, but had been the person who had brutally murdered his own mother. And what he went through is really indescribable. There is a happy ending, obviously, a little bit of one. Michael was cleared, and we were able, through DNA, to identify the person who had actually committed the crime. So there's a little spoiler in that one, but I'll tell a little more about it. This is Christine Morton, Michael's wife. They met in college. They had a really wonderful marriage. They were equals. It was in the early 80s that they got married. She had a career. They split childcare duties. She was a feisty and free spirit who he loved very much. This is their little son, Eric. They struggled to conceive, and when Eric was born, this picture, he's almost 2. He looks very small because he had a heart condition. One of the things that was so ironic and cruel and wrong about Michael's prosecution was it was alleged that he had murdered his wife in the middle of the night when she refused to have sex with him on his birthday. It was a made-up theory to come up with some kind of motive. And the family had gone through such tragedy that Michael had said to me many times, like, that was really the least of their problems, in part because Eric was born sick, and anyone who's had a sick child knows that consumes your whole world. And at the time that Christine, Eric's mother and Michael's wife, was murdered, Eric had just had major surgery. You can see the scar down his belly, and had come out of it well. He had a heart that was finally functioning. They didn't have to watch him every second, worried that something would go wrong. And he was finally starting to run and play like a normal child. Everything turned to tragedy in August of 1986. Michael goes to work early in the morning. He used to leave at 5 a.m. to go to his job as a manager at a local supermarket. And Christine would take Eric to the daycare center. Michael would get off work and pick him up. And he got a call from the daycare center saying that Eric hadn't come today, and was he sick? And he said, no, Christine was supposed to take him. And he knew immediately something was wrong. Obviously, Christine would have called him if she wasn't going to drop him off. So he knew that something must have happened to Christine. So he races home. He sees police tape around the house. And someone had come in shortly after Michael left for work and bludgeoned Christine to death in their bed. Eric had been found by a neighbor wandering around in their yard. She took him in and called the police. When Michael got to the scene, the first thing he asked was, is my son okay? And the police took that as a suspicious comment. How did he know his wife was okay? Well, he would later explain, I knew something must have happened to her because she didn't call me to tell me she wasn't bringing Eric to daycare. But husband's the first suspect. You know, it was a suburban community in Texas with a lot of, shall we say, law and order prosecutors and sheriffs at the time. Many people had moved to this suburb to get away with what was perceived as a rising crime rate in Austin, the nearest major city. And there was a lot of pressure to solve this crime very quickly, and frankly, to reassure the community that there was not some serial killer on the loose. If there was a husband who had done it, that was something they could handle. If there was a wild serial killing intruder, that was something they couldn't. So Michael was convicted, no physical evidence except for what was spun as medical evidence. It was the testimony of a medical examiner, Dr. Roberto Bayardo, who said that based on Christine's stomach contents, he could tell that she died no later than 1:15 in the morning because of how her food was digested. He said, and this actually came in without objection, that it was based on his experience, but it's not a scientific statement. He had originally estimated the time of death before Michael was a suspect as between 1 and 6 in the morning. And since Michael clocked in at 5, that would have allowed for his alibi potentially to clear him, or at least for the possibility that Christine was still alive when he left for work. He changed it a few weeks later, right around the time Michael was arrested, to say 1:15, and it was scientifically baseless. The prosecutor, then the elected DA, Ken Anderson, who was trying his first murder case as elected DA, said to the jury, much more than the doctor said that makes the time of death 1:15 in the morning, and that makes Michael scientifically proved as the killer of his wife. And later, the jurors would say that testimony was what sealed it. A doctor came in and said he had to have killed her because she died at the time when Michael, by his own admission, was the only person in the house. And there was really nothing else. They spun, none of you ever, trust me, want to be on trial for murdering a spouse, because everything bad you've ever said to one another that someone overheard will come up. I look back at that transcript and thought, ooh. But in all seriousness, it was, he was grieving, trying to raise his son who had just lost his mother, and then essentially having his marriage put on trial because there was nothing else. Michael got convicted pretty quickly. His defense lawyers actually were terrific. He and his family scraped together every dime they had to hire good lawyers. They put on their own medical experts to contradict the states, to no avail. And he spent the next 24 years in prison. He'd been out on bond to be with Eric pending the trial, but he was taken from his son. This is about how old Eric was when he went to prison. I'm gonna pull a trial lawyer move and really tug at your heartstrings for a second. And in all seriousness, I wanna show you vividly through the photos of Eric what Michael lost during that time. Sometimes, especially those of us who work in criminal justice, we're like, oh, we got 10 years, you got 20 years, you got 30 years, life sentence. Those of us who have asked for sentences or defended them think of them in this years. But when you are a parent, when you're a human being, that time goes real slowly, and it also goes real fast. So these are just a few photos from the time in between when Michael went to prison and when he finally got out of Eric's life that he missed. That is Eric on his honeymoon about 8 months before Michael got out of prison. His wife, Maggie, who he's still with, you might notice she bears a very distinct resemblance to another beautiful blue-eyed brunette. And they have a baby daughter now named Christine. Michael did not make it for their wedding, but I will tell you he did make it home in time for Christine's birth. He did not see much of Eric during those years. There was a court order for Eric's aunt, Christine's sister, to bring him, but she also was told and believed that Michael had killed her sister. And so Eric eventually said he didn't want to come see Michael anymore, and around age 12, he wrote him a letter and said he wasn't going to visit anymore. And that nearly broke Michael, but he did get through it. So now we start for the better part. This is the bandana that the real killer left, kind of Cinderella style, about 100 yards from the crime scene. Most of our cases involve a lot of hard work by a lot of people. They also involve a lot of luck. And among the very lucky things was that the killer dropped this bandana, that it had trace amounts of Christine Morton's blood on it, as well as the killer's own DNA, his skin and sweat cells from when he wiped his face off. Christine's brother-in-law, not the police, actually found it during his own canvass of the neighborhood, and miraculously, that piece of fabric was saved on a shelf for 25 years. We almost didn't get to test it. We were in court for 5 years, up and down the courts in Texas, trying to get a simple order to let us send it to a lab at our own expense. That has happened, I have to tell you, all too frequently in many of my cases. My first exoneree in Florida, Wilton Dedge, was in court for almost a decade trying to get DNA testing ordered. And when we finally did, after the state said there was no point in doing it, we got a match to a serial offender whose photo I'll show you in a bit. But it was the DNA that ultimately proved Michael's innocence. What really galvanized reform in the state, though, was something else we discovered along the way. Through a Public Records Act request, we found a police report that the sheriff sent us, not knowing that this had been held back at the time of trial, of an interview that the grandmother, Christine's mom, had done with the lead detective in the case reporting and giving him on tape her verbatim notes that she wrote down immediately after of the first conversation she had with young Eric, who was 4 years old, about what he saw. A week after the murder, everybody knew Eric might have seen something, but about a week after the murder, he finally told his grandmother about this monster that he saw hitting mommy and breaking the bed. They'd all hoped that Eric might have seen the man coming or going, but hadn't seen the crime, but he described it in hideous detail. Things that nobody who hadn't seen the room and seen the crime would have known, that she had a blue suitcase piled on top of her body on the bed. The killer had left her covered up with a suitcase on top. And he had on gloves, red. We think that means he either had blood on his hands or he was wearing red gloves. He had a basket, which was also left on top of the bed. There was wood, which was the murder weapon. And then the monster left, and his grandmother asked him, "Where was Daddy, Eric? Was Daddy there?" And he said, "No, Mommy and Eric was there." And at that point, Christine's mother told Sergeant Wood, "Get off the domestic thing now and look for the monster. I have no more suspicions in my mind that Mike did it." Christine's mother is older now and suffers from symptoms of dementia. And we don't know what was said between her and the detective to eventually get her back to the place of thinking that Michael did it. But this statement was never disclosed. Michael had never seen it before. His lawyers had never seen it before. Whether the child could have come in at age 4 to testify as a witness, we don't know. But this was obviously textbook Brady material. And we know that the prosecutor knew about it because it was in his file. And after it came to light, several people who used to work in that office said they remembered being present for strategy meetings in the office where he talked about what to do about this statement and what they would say about it if the defense got it. There was also a bunch of other Brady material. I don't have time to go into it all, but among them there was a male who neighbors had seen park a green van behind the house and get out and search the wooded area off the road. That's the direct path on which that bandana was found. The killer, Mark Allen Norwood, whose DNA was on the bandana, drove a dark yellow van at the time, and we think it probably looked green in the light of those trees, or as we all know, witnesses can be mistaken on color. It was another important lead that was never followed up. Mr. Norwood did not have a particularly violent criminal record that we knew about at the time. He had some drug convictions and a burglary conviction or two. He was in the database, the national database in California, not in Texas, but he was living in Bastrop, Texas, sitting on his mama's front porch when we got the DNA hit to him. Still took the prosecutors another 4 weeks to go interview him and arrest him. And it was only after we got prosecutors from another county to agree to do DNA testing in another case of a young wife and mother who had been brutally murdered 2 years after Michael went to prison in the next door county. Same MO, victim was about the same age, also a brunette, and in another stroke of incredible luck, marking the end of the tragedy, Mark Norwood's pubic hair was found in her bed. After that happened, the prosecutors finally said uncle and agreed to exonerate Michael and give him an innocence finding. The other detail, it was not in the clips I showed you, but in Eric's statement, was that the monster had a big mustache. And this is a photo of what Norwood looked like back at the time of the crime, and you can obviously see the mustache on him. This is Michael on the day he got out with his parents who stuck by him all of those years. And it was, again, a joyful day, but one marked with a lot of pain. What came after was extraordinary and quite unprecedented. You might remember the drawing I showed you of the DA in the courtroom. That is the prosecutor, Ken Anderson, wearing an orange jumpsuit because he went to jail for having, after he pled guilty to 1 count of criminal contempt for lying to the judge. The judge had actually asked him on the record prior to trial, because the defense smelled a rat and thought that there was material they hadn't gotten, "Do you have anything favorable to disclose to the defense that you have not already turned over?" And he said, "No, sir." Texas has a very unique procedure where citizens can bring a criminal complaint to a district judge for government officials who are alleged to have committed criminal conduct, the theory being, often correctly, that a local prosecutor may not prosecute another local powerful official. Ken Anderson had become the chief judge of the county in the years since Michael's conviction, and we knew that the same prosecutor who didn't even want to give us a DNA test was not going to give us a criminal inquiry against Ken Anderson. But we brought it to a judge. They brought in a neutral judge from outside the county, appointed by the state Supreme Court, and he found probable cause to have Anderson arrested. And a few months later, to resolve the case, he pled guilty to criminal contempt. He got 8 days in jail. He served 4. Obviously, that's symbolic more than anything, but it was a big symbol. And many people in the state told us that junior prosecutors were coming into the offices saying, "I don't want to be the next Ken Anderson. I'm going to make sure I don't screw this up." He was also disbarred. He agreed to give up his law license permanently, which also very rarely happens. John Bradley, the DA who opposed DNA testing for us, got taken out the old-fashioned way by the voters. The Republican voters of Williamson County decided they had had enough, and they were horrified and outraged by this case. Some of them, not me, I promise, went around and hung bandanas on John Bradley's yard signs during the campaign. I can't lie and say that I didn't take pleasure in that, but elections sometimes work. They matter. They're not a substitute for judicial action, but when people are motivated, they will send a message. On the legislative front, after Michael's case, we were able to change the rules. We were able to have Ken Anderson disbarred and prosecuted for criminal contempt, because those of you who are judges in this room may be pleased to know that there's typically no statute of limitations on contempt, because it's, crimes against judges continue forever. But against the rest of us, there often is one. And the state bar rules typically require that you file your complaint against an attorney within 4 years of when the misconduct is committed. But in wrongful conviction cases, we often don't discover it till decades later. And so the all-Republican legislature came in and changed the law to say that where you are alleging prosecutorial misconduct, the statute of limitations won't begin to run until the date the person's released from prison, which is really important, because if I had discovered the Brady material very early in the litigation, I might not have wanted to go file a grievance against the prosecutor while my focus is trying to get the client relief, or create a reason why a judge might protect that person or a prosecutor might oppose us. So it's from the date they actually get out of prison. The biggest change that came out is we got statewide discovery reform in Texas. You all have had a much better set of discovery rules than Texas, or dare I say my pathetic home state of New York in that department, for a long time. But in Texas, it was really a closed file jurisdiction. They came together. This is then Governor Rick Perry, first public bill signing he had of the 2013 legislative session, unanimously passed by the legislature after a lot of compromises and negotiations, but it is very meaningful discovery reform that finally makes just about every piece of paper and every electronic document and bit of information available to defenders in the first instance, with some privilege exceptions and some exceptions for witness safety. It's called the Michael Morton Act, and I occasionally get briefs now talking about people's Morton disclosures and have they complied with Morton, and it's kind of a wonderful thing to see after all those years in the wilderness. Okay, so that was Michael's case. Other things that are happening in Texas that should create some envy/inspiration here in the state of Florida. On the much more positive front than the pitched battle we had to clear Michael for all these years, we have had, as I mentioned, some really extraordinary relationships with prosecutors' offices in big jurisdictions and small ones. One of them is in Tarrant County, Texas, the district that covers Fort Worth, in which a Tea Party Republican named Sharon Wilson was elected a few years ago and created, as I mentioned, this conviction integrity unit. It is a unit that is separate and apart from the appeals division. They hire, if they can, their own staff. The person she hired had been a career defense lawyer who had never worked in the Tarrant County DA's office. She'd been a public defender in the neighboring county, because they want someone who's got independence, who won't know the players. Ultimately, the DA has to make the decision about what to do about a case, but these units are empowered to investigate and review cases from the opposite perspective that we typically get on appeals, where the question is, can we find a procedural ground to kick it? Can we fight it? What's this frivolous motion this guy's making yet again? Obviously, not all appeals units approach their cases that way, but it tends to be a struggle against everyone's usual instincts. You'll see that there I am standing at the district attorney's podium. I think it's the first and maybe the last time I will ever get to have a press conference at the DA's podium with no DA present. The guy on the right is my co-counsel. They just said, it's your day, go ahead. It was really their day too. I mean, they spent 3 years reinvestigating this case. John was, it's interesting, right? Because we all know the many complex and in some ways extremely troubling and intractable ways that race can play out negatively against people of color in our justice system. John was convicted of murdering a female platonic friend of his who was white. I think that is probably the main reason why he became the suspect. He had been visiting her earlier that week. She was the widow of an old coworker of his, and they had remained friends. He and his girlfriend had hosted her and her children for Thanksgiving that year. That explained much of the original prosecution. There was almost no physical evidence against him and no real motive. But when it came time 20 years later to reinvestigate the case, in Michael's case, a white college-educated guy with no record, we had a pitched battle. In this case, a black man convicted of killing a white woman who had a, minor but still some criminal record before then, we got a very different reception. And they put thousands of hours. Together, we interviewed more than 70 witnesses. We did 100 forensic tests. And at no time in the 12 years I represented John did I ever file one contested motion. Everything was by agreement. It took a while, but we got there. Part of how we got there was an investigation that only the DA's office couldn't have done. I could never have done it on my own, or at least it would have been very unlikely. There was a jailhouse informant in John's case. It was probably the most significant evidence against him, a man who said, and you all probably know this song, I was in the law library, and he came in asking for legal advice. And I said, tell me about your case. And he gave me this, the first 5 minutes I met him, this full confession to this murder. And the informant got up on the stand, and even though he had, serious pending felony charges and a long record, he had managed to get deferred adjudication probation, but insisted there was no deal, and insisted, moreover, that he had never snitched on anyone before, ever, had never even offered to. So I knew that was almost certainly not true. But we didn't have any records in his file. We didn't have any other records to show otherwise. So I asked the new prosecutor, the conviction integrity prosecutor, can you see if there's any other records? And a local defense lawyer had told me, back in the 90s, I remember there was this committee called the Snitch Referral Committee. That was actually the name. It was like an employment service for snitches. Like somebody would come in and say, I've got these skills, I've got these ties to these drug gangs. And legitimately, they would sometimes put them out to work for informants, in gangs. Other times, I think it led to a lot of abuses where people would just say they were willing to work, and suddenly they'd be in a jail cell next to somebody who was facing a murder charge. So a few weeks later, this prosecutor, having rooted around in those old files, she said she'd never heard of this committee. She'd check. She calls me and she says, you might want to check your email. And all of a sudden, I get 12 pages of files on John O'Brien, the jailhouse informant, including a letter from his attorney dated December 16th, the week after my client's friend was murdered. Here's an outline of the information, which he believes could be of assistance to your office, and a 6-page proffer on all the people that he had ties to who he thought he could implicate in various crimes. Then we get another letter from one prosecutor to another on the committee. It's not highlighted, but the second sentence you can see, his attorney's Rob Long, and as I told you, he's saying he wants to work as a snitch. So other than holding up a sign on the highway that says we'll work for probation, it couldn't have really been more clear what his motive was and what he intended to do. When that happened, the DA's office very quickly said, we'll vacate the conviction. Texas has a very harsh and unfair legal mechanism in which the high court has to approve any writ that is granted, even if the prosecutor and the district judge are in agreement. So it sat there in various stages for about 2 years. And then after the conviction was finally vacated by the high court, we had another 6 months of investigating to do before the DA was prepared to formally declare John innocent. And the reason that was important was not just to clear his name, but also to make him eligible for compensation under Texas law. In the meantime, during the 2.5 years that John was on bail, the DA, to her credit, did not just rest on her laurels or focus on this one case. She went and had every single file in those old snitch committee files put into a database. They gave notification to any defendant in which those informants had testified to let them know there was additional informant materials in those cases. And she revamped her office's internal policies to create a 2-page detailed checklist of information that every single prosecutor must certify that they have investigated and disclosed about benefits, about prior cooperation, about statements, about incentives. That internal policy became the model for a recommendation by a statewide wrongful conviction review commission that had been set up a few years ago, which then became the model for a statewide bill. The bill largely tracks the internal policy that the DA in Fort Worth adopted. It was passed last year, and it doesn't change the substantive law in Brady, but it does require every single office to have a tracking system and certify that they have a way to track what benefits informants are being given. So it creates the tools for meaningful compliance. In case you're not inspired yet, get your competitive juices up. Here's some more reasons not to mess with Texas. And in a state, I will say, and this is really why these issues are not always breakdownable on traditional Republican, Democrat, prosecutor, defender lines. In a state that for pretty much the entire time we've been trying to get legislation passed has been controlled in both chambers by Republicans with Republican governors, We have created a forensic science commission that's staffed by 7 scientists and 2 lawyers, 1 defense lawyer and 1 prosecutor, that reviews complaints about forensic error or misconduct and makes recommendations. One of their landmark recommendations is a couple years ago, they issued a big report saying that bite mark evidence, a dentist who says they can tell if a defendant did or did not leave a certain bite on a skin or other substance, is total junk. It's unreliable. It should never be admitted into criminal courts. They said it in a much more measured and fancy and detailed way than I just did. But there is, in effect, a statewide moratorium on bite mark testimony thanks to those recommendations. It's not court mandated, but because of the way the accreditation requirements work, we don't know of any other case where it's been admitted or even attempted to be used since then. They have the most generous wrongful conviction compensation law in the US, go big or go home, $80,000 a year for every year someone was in prison, plus they get access to state health care and a lifetime annuity of $80,000 a year for the rest of their natural life. So they can take the principal, buy a house, set up a college fund for their kids, put it away. They have enacted comprehensive statewide reform to their eyewitness ID procedures to reduce the risk of misidentification, which is the single leading cause of wrongful convictions in all of our data. They are the first state to create a special writ that allows you to come back into court when there's been a change in science. Typically, and some of you who've handled or heard these cases may know, if you're saying that science has changed around bullet analysis, around hairs, around shaken baby syndrome, you have to come in and effectively litigate from the start whether you have filed that within the 2 years or so that are typically allowed for a writ, and get bogged down in all of the procedural hurdles of whether you can bring your claim at all, not to mention whether the court finds it persuasive. In Texas now, you get a fresh time clock and a clear express lane to get to the merits if you can show that there is previously unavailable science, doesn't have to be unavailable within any set time period, just not available to you at the time of your trial or plea, that either provides new evidence supporting your actual innocence or contradicts evidence that was presented at trial. Importantly, the legislature decided that they did not need the scientific evidence to actually prove innocence. It's enough that it probably would have changed the result, because they recognize that, especially when we're talking about science, it may not always go to a decisive issue in the case, but can be enormously persuasive to juries in what is, often an otherwise dubious case. So you get a new trial, you don't necessarily get exonerated, but we've had a number of people get cleared that way as well. And Texas has also passed mandatory electronic recording of police interrogations, meaning they don't just record the ultimate confession or admission, they have to record the entire statement from start to finish in most felony cases. Okay, Florida. Here's what you've done so far for exoneration. Some of you may know these numbers already. There have been 64 exonerations since 1972. That ranks you 7th among all states. DC and Puerto Rico. Obviously, this is still a limited data set, and where a state ranks in exonerations can be influenced by a number of factors. I don't think it's a proxy for how often we get it wrong or get it right. I mean, we don't have an Innocence Project in Alabama. We have not had robust judicial review in many places there of claims of wrongful conviction. I don't think it means that Alabama, if they have a few exonerations, is doing necessarily a better job at getting it right the first time. Here, I think we probably have a confluence of some serious error the first time around and some really terrific lawyers and judges, and in many cases prosecutors, who have worked to rectify those injustices. 12 of the 64 exonerations are based in whole or in part on new DNA evidence. That puts you 8 among states nationally. And death row exonerations, you're number 1. Depending on how you count, I want to be careful about this data. If you include the cases, and it's not an insignificant number, I think it's about 7, in which the Florida Supreme Court has thrown out a death sentence and a conviction on direct review for insufficiency, then you are number 1. If you only count the ones in which the conviction was overturned based on affirmative new evidence under Jones v. State or otherwise of innocence, you are number 2, back after Illinois. But it's a big number. Interestingly, though this will not be an issue going forward since you've changed the law, but 90% of the cases in which people were exonerated after being sentenced to death had non-unanimous juries at sentencing, suggesting that there was probably some residual doubt in place from those cases, or maybe not, but folks who would not have been on death row had there been a requirement of a unanimous jury. Okay, it's showing me these again. Okay, so here's what's been done so far on the legislative front and through court rules. First, you should be pleased to know you have a very robust post-conviction DNA testing and evidence preservation statute. Some of you may remember back in 2003, and some of you may have gotten calls from me in my young lawyer days when we were scrambling to get DNA motions filed before the evidence preservation provision in the first stage of the law sunset. Everything was potentially going to go in the garbage if the Florida Supreme Court or the legislature didn't act. The court issued an emergency stay of the law, saving hundreds of cases potentially from destruction, and the legislature then stepped in and extended the law. It meets all of our minimum indicators for a robust law that gives people reasonable access to testing. And we can't do anything about evidence that was thrown away years ago, but certainly the evidence that has been saved is now sitting there through the time when someone has finished serving their sentence, including any post-release supervision. Last year, the legislature passed a pretty good, though not perfect, reform to eyewitness identification procedures. The main feature of it is that it requires that the person who is showing the witness the lineup or the photo array not know the right answer, meaning who the suspect is, because there's been a lot of research showing you can unconsciously convey cues to someone, positive or negative. They pick out number 1 and you think the suspect is number 3. And they're like, I think it's 1. And then the person, the police officer, not intending necessarily to influence, will say, don't rush, keep looking. And then unconsciously or not, the witness takes it as a signal, maybe that wasn't the right answer. Or as soon as they say number 3, they say, great, we got him. And by the way, he confessed. And that solidifies what may have been a tentative ID, but it literally sears it in the witness's mind as the correct answer, which can be impossible to shake. They also have to give an instruction that the perpetrator may or may not be in the lineup. And the reason for that is then the witness is free to say, I don't see the person, as opposed to I'm going to pick the closest answer, like a multiple choice SAT test. You have generous compensation for some exonerees. As you may know, there is a pretty harsh, in my view, clean hands provision where someone who has just about any prior felony and even some misdemeanors cannot get compensated under Florida law. That has meant, I have one client, Orlando Boquete, who was a Cuban immigrant, came over here on the boat lift, who got exonerated with an innocence finding, full support of the DA down in the Keys in Marathon. He still has not collected a dime because while he was in prison, he actually escaped from prison for 11 years, and while he was on the run from his wrongful conviction, he got caught dealing in stolen property, some clothes to survive, and was in a house staying with other fugitives where a gun was found. And those are the only felonies on his record. He had a perfectly clean record before then. It was a struggle enough to keep him from getting deported, but because of those convictions, which are the direct result of his wrongful conviction, he can't get a dime. And we also have clients who had, relatively minor, sometimes even not so minor felony records, which is why they were in the system in the first place. But these are things that happened when they were 18, 19, 22 years old, and they get a wrongful conviction, they lose 20 years of their lives, and they are ineligible for anything. Informant testimony, the courts have adopted here a good new rule that to some extent tracks what we've done in Texas. Again, not changing the law, but codifying exactly what needs to be done. Those of you who are overseeing compliance judges or defenders should always make sure that there's a certification on the record that they have not only complied with the law in terms of disclosing what they know, but that prosecutors and police have made the necessary inquiries to assure that the right hand is talking to the left and everything about informants is disclosed. And then you have a burgeoning conviction integrity movement launched by, I think probably not coincidentally, 3 state attorneys in Jacksonville, Tampa, and Orlando who took office in the last couple of years. All this year, Hillsborough about to kick off, I'm told, very soon, launched by new state attorneys, all of whom have hired new folks to run these units and through a lot of hard work gotten funding for them in a tough climate to do so. Again, designed to follow the national model and do these reinvestigations. I would be remiss if I didn't give a shout out to Melissa Nelson, my friend who is here from Jacksonville, who actually was doing conviction integrity before there was even such a thing. Many years ago, with Hank's help, we brought her and Harry Shorstein an exoneration case out of Jacksonville when we had some favorable new DNA and were hoping to get their agreement to reinvestigate the case and prove innocence. And Harry, in his infinite wisdom, said, I I don't think the trial lawyers who worked on this case should actually be in charge of the reinvestigation. And then he called us up and said, I'm going to give you Melissa, you can thank me later. And then we did, because she did an extraordinary job. And it was the first experience I had had of really working cooperatively with someone on the other side, not just to get DNA testing, but to sit down and systematically go through, what do we need to know about this case? What are our problems? What are the issues? What do you think? What do I think? In a way that was outside the court process, outside the media focus, that really ultimately got to a good result. So here's what's coming next. We have a recording of interrogations bill that's a high priority for the next session. This is Anthony Caravela, who was wrongly convicted in Broward County at the age of 15. He gave 4 separate confessions over several days of interrogation. He had an IQ of 67. All 4 statements were different. Most of them did not match the crime in any way, except that they involved a dead woman. And he was convicted largely on the basis of those confessions, at a time when I think juries were less educated than they are now about the flaws. But only the final statements were recorded, not all the questions he was asked and the initial answers that he gave. So his case is sort of the poster child for why we need recording start to finish. Many of you may know that if you are a police officer accused of misconduct, even something that could just lead to disciplinary action, you have a legal right to have your questioning recorded from start to finish. But if you are a police officer doing the interrogation, under current law, in most places you don't have to. Broward actually voluntarily records interrogations now, and many other jurisdictions do. But because it is voluntary, the police chief or the prosecutor can refuse to do it at any time, and there is no remedy if they decline to do so. There's no legal right to have it done in terms of suppressing the confession or getting a curative instruction. We are also looking at a court rule on change in science. I won't get into the details, but if you're interested, feel free to contact me for more information. It looks like it has to be done through the courts because it involves what evidence is sufficient to overcome the current 3850 and 3851 rules, but there is some potential for getting that cleared as well. And I promise you, in the end of the day, it will save time, because nobody likes wasting their time arguing over procedural bars. It's really a waste of everyone's brains. And then lastly, I'm going to leave you sort of where I began, with the human stories behind these cases. This is Clemente Aguirre, whose retrial in a capital case is starting this week in Seminole County. His conviction was overturned last year, 2.5 years ago, by the Florida Supreme Court, 7-0, based on new DNA and 5 separate confessions from the person whose DNA was found in blood at the crime scene. The state did not consent to have him even get a new trial, much less even a new sentencing hearing. The court found otherwise, and after several years of litigation, led largely by Maria Deliberato, who's here from the Capital Defender Office, we were able to get his conviction overturned and his death sentence overturned as well. He is getting retried, even though the victim in that case, the 2 victims in that case, the mother and grandmother who were brutally stabbed to death in their home, it's their own daughter who had a history of being Baker acted, involuntarily committed to mental institutions more than 60 times, and has since confessed to 5 different people, I killed my mom and grandma. But even with her blood all over the crime scene and those confessions, prosecutors are putting Clemente on trial again. He had the misfortune to be their next door neighbor who found the bodies when he came over to borrow some beer. And because their blood was on his clothes, the train left the station very quickly. We have a great trial team, mostly volunteer lawyers who are doing the retrial. And all we can hope is that he will get a fair hearing this time. Ultimately, at the end of the day, sometimes these things don't get resolved otherwise, and you have juries. He has the additional hurdle of having come here as an undocumented immigrant. I don't want to speculate about whether the prosecution is seeking to capitalize on the prejudices that may be involved in getting a fair and impartial jury that can really hear the evidence, but I, ever the optimist, have some confidence that when the jury hears about the DNA and the confessions, that they will do the right thing. And ultimately, that is all we can ask, that we will have courts and juries that will have the courage to own up to our past mistakes and to do what we can to make sure that they don't happen again. So thank you very much for hearing me out.